real question isn't what was suppressed. The real question is, what is the actual defense they're putting forth? Is it really their defense that it wasn't me? No. What's happening behind the scenes is the defense is doing their job, a constitutional right, to defend somebody who's guilty of murdering someone else in cold blood. What the defense is doing is it's trying to chip away, buying through these suppressions to say, okay, what evidence can we rule out, in the hope that there's a plea that's coming. They know if they walk this guy into a trial, other than jury nullification, this guy's going to get hammered. And that's what's being lost in the press. Just because they've won a suppression hearing as to a cell phone and a passport and a loaded magazine means what in front of the jury? Nothing. Any prosecutor worth their salt is licking their chops to get this guy before the jury. The biggest thing that the defense is doing right now, and don't get it twisted or confused, is they're trying to chip away so ultimately they can come in and reach the best possible plea. They know if they go to court in state and federal and lose, the prosecutor and the judge is going to max them for the trial. So it's just a leverage position. But ultimately, ask yourself, what is their defense when they actually swear in the jury? What is it? The defense hasn't pled an insanity defense. They didn't plead any type of alternative theory. Right now, it looks like all they're trying to do is suppress enough evidence that they can try to prove to a jury that, hey, you've got to convict beyond a reasonable doubt. But keep in mind, beyond all reasonable doubt when you're in a criminal setting is not beyond in the exclusion of all possible doubt. It's reasonable. If a jury finds that, no, it's reasonable that that guy and that camera and that hood looks just like your client. If it's reasonable that the officer stopped them and identified him and found that a gun, and that it's reasonable that that gun was used because it matches and it was the same one that this gentleman, that's how juries convict. Ultimately, we'll review the jury instructions as we get closer so you can see exactly what to the beyond and an exclusion of all reasonable doubt. But remember, it's reasonable. All great prosecutors don't allow juries to hold them to a higher burden. They use that word reasonable. They match all of the evidence. They say, look, I'm not telling you to convict because of one thing. I'm not telling you to convict because of this. They say, I'm telling you to convict because I have connected the dots. It's all there in terms of motive. It's all there in terms of evidence. The defense knows it. They're doing a good job working to suppress because ultimately, look for this to cut a deal. Nobody's going before a jury on this. And if they do, then it can only be, in my opinion, it's because he had nothing to lose. Meaning the prosecution's plea offer was so severe, no possibility of parole, dying in jail scenario, that they had nothing to lose but to put it before the jury and hope for a Hail Mary.